Hello.
Hello, yes, Ashley, I'm sorry to bother you.
Organized by the World Zerick Chamber of Commerce, Mumbai chapter. I have the greatest pleasure to introduce my friend and colleague, Zerick Dastur. Zerick Dastur practices in the field of court litigation, dispute resolution, arbitration, and security law. Zerick is a triple gold medalist from the Bombay University. Zerick practice covers diverse areas of corporate, commercial, and regulatory disputes. And Zerick is also representing a number of clients in the manufacturing, engineering, port, infrastructure, and the mining sectors. Zerick practice involves representing clients before various courts like the Supreme Court, High Court, statutory tribunals, SEBI, NCLT, CCI, and many more. Zerick was a former partner of J. Sagar and Company, which is a law firm. Zerick writes for various newspapers and publications on corporate, commercial, and competitive law. He is a regular speaker at events organized by the Economic Times, VC Circle, Indian Merchants Chamber, Corporate Knowledge Foundation, and the World Zerick Chamber of Commerce. He is a member of the Law Committee of the Indian Merchants Chamber. Zerick has received an award for the Outstanding Zerick Young Entrepreneur and Professional of the Year in the year 2017 at the World Zerick Chamber of Commerce Global Meeting at Bengaluru in December 2017. With these words, I present to you Zerick Dastur.
Thank you very much, Mr. Dalal, for a very generous introduction. Thank you, WZCC, for organizing this event, and welcome to all our participants. Ladies and gentlemen, today we are in times which would qualify as a new normal. And in that sense, it is totally unprecedented. And rather than talking about the obstacles and the challenges that we are facing right now, my mind is drawn to a quote from Charles Darwin, who is credited with the theory of evolution. So Charles Darwin says that it is not the strongest of species that survive, nor the most intelligent, but those who are most adaptable to change. In this situation, we are facing change, and adaptability is the need of the hour. Just the other day, I was reading a story about the year 1664, when England and London faced a similar pandemic like the one which we are facing today. It was the bubonic plague. There was widespread death, disease, and destruction. They also were experiencing a situation like what we are experiencing today in the nature of lockdown of all regular activities. Schools, colleges, and universities were completely shut down. Amongst these was the University of Cambridge, which also shut down and encouraged all its students to go back home and work from there. One such student took this as an opportunity. He spent time himself working at home, working in isolation, and the work that he created during this period is today what we know as the laws of motion and the laws of gravitation. This individual is none other than Sir Isaac Newton. And Newton, in that sense, personifies the phrase which we keep hearing, then when life gives us lemons, we make lemonade. Meaning that when faced with trouble, when faced with crisis, we create these troubles and this situation into the lemonade of opportunity. And today, even as we face this lockdown, which is a unique situation, we see a number of success stories. The world is becoming virtual. We have virtual education, virtual meetings, virtual webinars, virtual courts, and even the other day I heard virtual weddings. So the wheels of industry and cycles of life will move on, and it is for us to adapt to these changes and move on along with these times. Even speaking of our topic today, in the context of lemons and lemonade, if you look at the lemon, that is the various concerns and issues surrounding aspects which we will speak about today, including our contractual issues, labor issues, issues to do with employer-employees, wages, issues concerning rent. We must understand that as we move forward in this difficult time, we will create with it opportunities. We will take along with us for the future the preparedness, the learnings, the awareness out of this experience, which will be the lemonade which we will take with us in the future. So having said that, let us now look at our topic today, which essentially is divided into three aspects. One is the impact on contracts and contractual rights as a result of COVID-19 and the lockdown. Number two is the impact in connection with payment of wages for employees. And number three is the issue about paying rent to landlords by licensees and by tenants. So taking our first issue, which talks about contracts. So here, as we know, because of the lockdown which has happened, there is a complete turmoil and performance of obligations under the contract have become extremely difficult in most sectors. People are facing breaches and liabilities are arising. Here, at the outset, I would like to discuss this aspect in two main divisions. One is the contractual aspect of force majeure, and two is the completely purely legal principle of discharge by way of frustration of contracts. Talking about the contractual aspects, when I started my legal career, I was told by a very eminent lawyer that there are two kinds of lawyers. One, the preventive lawyers or the transactional lawyers who draw up agreements. And two, the curative lawyers or the dispute resolution lawyers whom you go to when things go bad, when cases have to be presented before a court. Here, when we initially talk about force majeure clauses in a contract, you look at the role of transactional lawyers to draft crystal clear, unambiguous clauses which can come to your aid in a situation like this. Force majeure clauses are clauses which contemplate certain unforeseen events in the future, as a result of which contractual obligations, if these situations arise, the contractual obligations can be suspended. So the central theme of a force majeure clause is to keep a contract alive. It is like looking at contracts on ventilators. They keep the obligations, they keep the liabilities in abeyance, in suspension, until things get better. And as time passes, the contractual obligations, liabilities will revive in future. So that is the principal object of a force majeure clause, namely to keep the contract alive. It is also a unique way where God is everywhere. He even finds himself within our contracts, because this clause is known as an act of God clause. So many a times you will see there are events which are specified within a contract which will result in suspension of obligation. So looking at a force majeure clause, let us divide it into 4 significant components and aspects. Number 1, you define a force majeure event within the contract. Number 2, you define the manner of invocation of that clause. Number 3, and probably the most relevant, you define the consequences of happening of a force majeure event. And number 4, you talk about the bounded duty of mitigation for every party who's suffering from a force majeure event. So taking the first principle, which is defining force majeure events, many a times you will see clauses in a contract which say that on happening of a war, a strike, an embargo, or a natural calamity, or such other circumstances beyond the control of a party, which renders performance of the contract onerous, or which hinders the performance of a contract. So you have specific words which you define, which you contemplate in advance, like war or a natural calamity, and you have general words like such other circumstances which render the contract performance very difficult, which follow these specific words. Now, there is a legal principle called ejusdem generis, that whenever general words follow specific words, they draw color from these specific words and will be defined in the context of these specific words. So if you have a clause which talks about war or a natural calamity and such other circumstances, the term such other circumstances will be defined and will draw the same color as something akin to war or a natural calamity. So you will not be able to bring in price fluctuation, business risks, fluctuation in the price of raw materials as a force majeure event within the general term. So therefore, as far as possible, try and define force majeure events within the contract, which according to you will result in the triggering of a force majeure clause. Talking of COVID-19 and a pandemic, if you see many of our force majeure clauses, you will find rare instances where pandemics will be specified as one of the force majeure events, because until now, none of us really contemplated that such a drastic thing could really happen. However, when many of the force majeure clauses you will see will include the term natural calamity, and the Ministry of Finance and the Ministry of Shipping, for example, have already issued notifications which say that COVID-19 should be treated as a natural calamity for the purpose of invocation of a force majeure clause. So that gives us some indication as to how the government and the regulators are thinking on this particular aspect. Number 2 is the aspect of invocation of a force majeure clause. So normally you will see contracts which say that within 7 days or 10 days of happening of a force majeure event, you must notify the counterparty about this particular aspect. Time is of the essence. You need to do it quickly, and you need to do it within a particular specified time frame within the happening of that particular event. Many a times in large scale executory contracts, you will see that performance, the time which is excluded, where the liabilities are suspended, will be compensated by way of a proportionate increase in time subsequently to complete the project. So you can build that in also in your force majeure clause if you're looking at compensating time which is lost as a result of any force majeure event. Thirdly, and most important, are the consequences. You need to specify within the contract the consequences of happening of a force majeure event. So there are 2 aspects here. One is that the obligations and liabilities of a party suffering from the force majeure event will be suspended until the force majeure event abates. So this is a special feature of a force majeure contractual clause where all the obligations, all the liabilities will remain suspended till the time the force majeure event continues. You will also see clauses which talk about termination, which say that, for instance, if a force majeure event continues for 90 days or 120 days, you will have a right to put an end to and terminate the contract. So that is the second and third aspect of the consequences of a force majeure event. And lastly, you will see clauses which specify that it is a duty of a party suffering from a force majeure event to continue performing the contract. It does not absolve a party from complete performance. You need to perform to the extent possible. You need to figure out alternate modes of performance, alternate supply routes, alternate labor, and all such other alternate arrangements as far as possible to continue performing and show your bona fides. So briefly, this is the background in connection with force majeure clauses. Now let me tell you how judiciary has been looking at force majeure clauses in the past few days as a result of COVID-19 and the pandemic. And I'll draw your attention to a case decided by the Delhi High Court, where the litigating parties were Halliburton and Vedanta. Just before I tell you the facts of this case, I'll give you a very brief summation on the principles governing invocation of bank guarantees. Many a times in contracts which require performance, you will see parties giving bank guarantees to the counterparty, which secures the performance. The law in connection with restraining invocation of bank guarantees is extremely strict and rigid. Courts will grant reliefs and injunctions on invocation only in the rarest of rare cases. And the norm is to uphold the guarantee contract and not grant an injunction or a stay on bank guarantee. So this is generally the legal principle which we need to keep in mind while we discuss the facts of this case, which are as follows. So Halliburton had contracted with Vedanta for development of certain oil fields. As a part of the contract, they had given 8 performance bank guarantees. Thereafter, while the contract was ongoing, the COVID-19 pandemic broke out, the lockdown happened, and Halliburton wrote to Vedanta that because of the lockdown, they were currently not able to perform, and they had a force majeure clause within the contract. So they invoked that clause and said that because of the force majeure, they were exempted from performance for the time being, and the bank guarantee should not be invoked because this is not their fault. This is a lockdown which is imposed by the government. When they did not receive a favorable response from Vedanta, they were constrained to move the Delhi High Court. And Delhi High Court looked at the force majeure clause, looked at the situation, it said, yes, this is a unique situation. There is a force majeure clause. There is a lockdown. Performance is not possible. And therefore, they did grant a stay on invocation of bank guarantee. Now, as I said, this is not the norm, but it gives you an insight into how courts are thinking, how courts are looking at this situation to arrive at working solutions as a relief-oriented approach to grant reliefs in the current situation where everyone is suffering. So this is something which gives some insight as to how courts are looking at force majeure clauses. Now, coming to the second aspect, which is the concept of frustration of contracts. Now, this is a purely legal principle, and the statutory framework can be found in the Indian Contracts Act in Section 32 and Section 56. Section 32 talks about contingent contracts, contracts which are contingent on happening of a certain future event are only enforceable if that event happens. And largely the focus of our discussion is Section 56 of the Contract Act, which says that the contract to perform an impossible act is void, and a contract which subsequently gains the color of impossibility after entering into the contract becomes illegal or becomes impossible that contract will also be void. So this is the legal framework covering frustration of contracts, and it's purely to deal with law. As they say, there is no better way to exercise your imagination than the study of law. No artist can interpret nature as freely as a lawyer will interpret a contract. So here, talking about frustration, there's a whole gambit of law from 1954 to 2017, where Supreme Court has analyzed case after case to understand and decide whether or not to grant the relief of discharge by way of frustration. And if I were to summarize this law spanning over 70 years into 4 broad principles, they would be as follows. Number 1, frustration and discharge by way of frustration is an exception. It is not the norm. Courts are highly reluctant to discharge parties by way of frustration, and it is only in exceptional cases that the remedy of frustration of contract will be granted. Number 2, just because a contract becomes difficult to perform or onerous to perform, it does not mean that courts will absolve you by way of frustration. It has to be something far, far more drastic. It has to be something which strikes at the root of the contract and completely changes the color of the contract so as to render it completely impossible or impracticable to perform, which will result in the remedy of frustration. Number 3, and a particular difference and distinction from a force majeure clause, is frustration discharges parties from performing the contract. It puts the contract to an end. It renders the contract void. Unlike force majeure, where the idea is for the contract to survive, as I said, contract on ventilator. It is a means to keep the contract alive by suspending the obligations for the time being. But when you invoke the legal remedy of frustration, there is no suspension. If you succeed, the contract will be discharged and the contract will be terminated. So that has to be something which is to be kept in mind. And finally, there has to be some form of permanence in the grievance which you have. For example, there was a recent case in the last few weeks before the Bombay High Court concerning certain shipment of steel products from Korea. So shipper was from Korea and the importer was in India. And the shipment concerned shipment of steel. The shipment was dispatched, and after that, the COVID-19 pandemic broke out and the lockdown also consequently followed. So the Indian importer moved the court saying that the contract was frustrated because of COVID-19 and the lockdown and he could no longer perform the contract. But Bombay High Court said no, COVID-19 and lockdown is a temporary event. For you to get the remedy of frustration, you need something far more permanent in nature. And in any case, the shipment related to shipment of steel products, which were essential commodities, which were in that sense exempted from the lockdown. So in that sense, this gives you a semblance of an idea that courts want something permanent in nature, some kind of an impact on the contract, which is permanent in nature for them to grant you the remedy of frustration. So these are the 4 broad principles which have evolved over a period of time, which deal with the law of frustration of contracts. And now I will give you 2 broad examples, one of the exception to the rule and one to the norm. When you talk about a remedy of frustration, as I said, it is something so significant which is independent of the contract, which affects the contract, which renders the performance virtually impossible. So, to give you a live example, there was a case which I had handled in connection with one of my clients in Chennai. Now, the case pertained to the Chennai port. This was a port-oriented contract. So in ports, as you know, vessels come in and there are around 10 to 15 berths where vessels can come in and berth and loading and unloading can take place. So like any other port, Chennai also had around 10 to 15 berths. And in 2004-2005, the situation was such that there was a huge traffic and huge traffic congestion because of the number of vessels which were coming in, the number of ships which were coming in. As a result of which, there were long queues in which people had to wait to avail their berthing turn. So you had to wait for the earlier ships to complete their loading, unloading, and this process may take hours and sometimes days and weeks. So that resulted in a loss of time and a loss of money. Therefore, to deal with this congestion problem, the government came out with a scheme which is called the Berth Reservation Scheme, where one of the 15 berths would be given on a license to a party for around 15 to 20 years by paying an upfront annual amount to the government every year of berth reservation charges. So my client participated in a tender and won such a license where he got one berth for exclusive use as a reservation. And what he had to do is he had to pay an annual sum in advance every year to the port as license fee. And he could use this berth and enter into contracts with various ships and shipping lines and vessels who wanted to avail priority berthing, who wanted to jump the queue and avail a reserved berth. So they used to pay the client an extra premium, which was the profit element for my client. And if a shipping line would pay that extra premium, they would get a reserved berth and they would jump the queue and get berthing on a priority basis. So this was the scheme of the contract. Now this contract and the scheme worked very well for the first 10 years. There was no issue. But in 2014, a unique incident happened. In 2014, the Madras High Court passed an order in a PIL which said that there will be a complete ban on handling any dusty cargo in the Chennai port. So any vessel carrying dusty cargo like coal or iron ore could not come into Chennai port at all. And there was a separate port around 80 kilometers away called the Ennore port, which was constituted only to handle dusty cargo. So the consequence of this total ban on dusty cargo like coal and iron ore was that there was a drastic drop in the number of ships and vessels calling upon the Chennai port. As a result of which, there was no waiting in queue, as a result of which, there was no congestion, and as a result of which, there was no need for anyone to avail priority berthing or berth reservation from my client. My client saw that the contract was completely eroded, and they applied to the port that please discharge us from the contract. The contract is obviously frustrated. No one needs priority berthing. Berths are freely available. Why will anyone pay me a premium for this purpose? The purpose of the contract is lost. But port and government authorities, as we know, they refused. So the matter went into litigation. And the courts, looking at the situation, came to a conclusion that yes, congestion of traffic was the essence of the contract. Priority berthing and berth reservation is dependent on the volumes of traffic accessing the Chennai port. If there is no traffic, if there is no congestion, then there is no need for priority berthing or berth reservation. As a result, the scheme is totally redundant. As a result, the contract has been completely eroded and the contract has been frustrated. They granted us the relief. They discharged our clients of the obligations of the contract and upheld our argument that the contract was completely frustrated as the pure essence of the contract, namely congestion, which was addressed by priority berthing, was lost. So this is an example which I would say is an exception to the general norm that courts normally are not inclined to grant the remedy of frustration in most cases. It's only in exceptional situation like this where the problem is so grave that the essence of the contract has changed, will courts look into or consider granting the remedy of frustration of contract. Now, having seen the exception, now let us look at another very famous case which signifies what the norm is. And this case was a judgment in 2017 passed by the Supreme Court by one of the most brilliant judges India has ever seen, and that is Mr. Rohinton Nariman. So this case pertained to power producing companies, and it is named Energy Watchdogs. So what had happened was there was a bidding process where the government of Gujarat required some people to provide them with power and produce power. So power producing companies had participated in the bid. And there were a few companies who had put in the bid on the basis, they had an internal understanding, the bidders, that there were certain long-term contracts they had with entities in Indonesia who used to supply them coal at a particular price. So on the basis of that, they put in the bid and the contract was entered into. After entering into the contract, there was something unique which happened where the law in Indonesia changed. And as a result of the change in law, the price of coal skyrocketed and shot up. Therefore, it became totally unviable for these power producing companies to now perform the contract at the same price at which they had bid, because it became very, very onerous, it became very, very expensive. And according to them, the scheme had completely changed because they had bid keeping in mind certain existing facts. But now, because of a change in Indonesian law, the price of the raw material had increased, and they said that they could not perform the contract anymore at the existing price. So what did they do? They applied to the government saying that the contract is frustrated and they should be discharged. It was not their fault. It was a change in Indonesian law which had resulted in this situation. Now the matter was litigated upon, the government refused, and finally the issue went to Supreme Court. And looking at this situation, looking at 70 years of judicial history and case law and precedent, Supreme Court gave a landmark judgment saying, no, there was no frustration. The essence of the contract is producing power. And nowhere in the contract was it mentioned that the raw material or the coal had to be sourced from Indonesia. There were alternate sources available. And even though they may be twice as expensive, even though it may be twice as inconvenient logistically, they still had to abide by their contract. There was no change. There was no frustration. The essence of the contract was to produce power, and the essence remained the same. So long as there were alternate routes, there is no frustration. So this basically summarizes the entire judicial position. Just because the contract becomes onerous, just because there are business risks that we are subject to, price fluctuations that we are subject to, that cannot become a facet to seek discharge from performing a contract on the basis of frustration. Very interestingly, while discussing this aspect, Supreme Court referred to another case of an English court in the year 1954. Now, that case pertained to shipment of certain goods from one country to another. And at that time, the normal route for shipment was the Suez Canal. And that was the most economical route which was used by most shippers during those periods. Now, what happened in 1954? A war broke out and the Suez Canal was shut. So basically, it could not be used for the purpose of transfer of or transit of vessels. So the party, who's the shipper, filed a case saying the contract was frustrated. He could no longer perform because as a result of the war, the Suez Canal was shut and he could not transport the goods. When the matter went to court, court said no, there is no frustration because there is an alternate route which is available and you can go all the way down Cape of Good Hope under South Africa and perform the contract. And even though that route is twice as expensive and twice as long, so long as there is an alternate route, there is no frustration. So that essentially summarizes the Indian legal position. And based on English legal cases, which say that the norm is no frustration, only in exceptional cases where things are beyond the control and completely erode the fundamentals of a contract, will you be given the remedy of frustration. A connected topic here is the aspect of, in some of these long-term infrastructure contracts, you will see that there is a clause called a change in law clause, which says that after entering into the contract, if there is a change in law which substantially affects the rights of one of the parties and renders the contract commercially unviable, the parties should renegotiate and amend the contract. So this is a unique situation, particularly for long-term infrastructure contracts, which span over 20 years, 30 years, where you cannot foresee the future. If there is any change in law, if there is a new tax regime which is implemented, it completely changes the equilibrium of parties. And therefore, in advance, in the contract, you provide for this kind of a clause where you can take recourse to that clause in case of happening of such an uncertain future event like a change in law, which renders the contract commercially unviable. So this is one of the important aspects to be kept in mind while drafting a contract, particularly in long-term infrastructure contracts, to provide for a clause called the change in law clause, which provides you with this remedy to try and renegotiate and change the contract by mutual consent. In this connection, as we deal with force majeure and frustration, we have seen a number of developments in the various ministries of the government. Ministry of Finance has issued a notification which says that COVID-19 should be treated as natural calamity and consequently will be a valid ground to invoke force majeure clauses. Similarly, Ministry of Shipping has also issued a notification saying COVID-19 should be treated as a natural calamity and that the ports should not impose penalties on port operators who are suffering as a result of this pandemic and performance which is affected as a result of this pandemic. We are also aware of the measures which have been taken by the RBI, which is the country's financial regulator, which has granted a moratorium on payment of loans for a period of 3 months from March, which has now been extended to August. So this is also something which gives relief to a number of borrowers who are unable to meet their financial obligation as a result of the pandemic and the lockdown. We also have the Insolvency and Bankruptcy Code. Now, as we know, this is a code which is invoked whenever you want to file petitions claiming that insolvency and non-payment of debt by certain companies. So because of the COVID-19 pandemic and the lockdown, it has been announced, which will soon culminate into a notification, that the government intends to suspend the operation of the Insolvency and Bankruptcy Code for a period of 1 year. This is obviously because so many companies are suffering as a result of the lockdown and consequently cannot or are unable to fulfill their financial commitments. So this is a positive move by the government in the context of the lockdown and the pandemic. We have the Supreme Court, which is also very active in this segment. And recently, it has passed an order suspending the period of limitation. As we know, for any suit proceeding to be filed, you have to file it within a specified period of time. And that is the period of limitation. So Supreme Court has suspended the period of limitation for the period of this lockdown. So this entire period of lockdown will be excluded and will not be taken into account while computing period of limitation for us to file claims. So this is also a very welcome relief-oriented measure, which will definitely help a number of litigants who are unable to file cases as a result of the lockdown. So this is the first aspect which we discussed about the impact of COVID-19 on the contracts, the contractual issue of force majeure, and the purely legal concept of frustration of contracts. Many a times this question comes up whether COVID-19 will be treated as a frustration event. But in most cases, of course, it has to be seen on a case-to-case basis. But in most cases where the contract duration is long, this could be treated as a temporary measure, and therefore it may be a challenge to get a relief of frustration on the basis of COVID-19 or the lockdown. But having said that, obviously, it depends on the nature of the contract, it depends upon what has been agreed upon, and it depends upon a case-by-case analysis to see whether the relief is applicable or not. Coming to the second aspect of our discussion today is a very interesting question about payment of wages. Now, there's a lot of uncertainty surrounding this aspect of payment of wages to employees. In March 20th of 2019, the Labor Ministry had come out with an advisory. Now, this is an advisory, it does not have the force of law. It had advised that employers should pay the employees in full and they should not deduct wages of employees. But this was an advisory. After that, on March 29th, this is very significant, the Ministry of Home Affairs, under the Disaster Management Act, issued a notification making it compulsory for entrepreneurs to pay wages to workmen and not terminate the services of workmen during the lockdown period. And there were penal consequences also specified within the notification. The notification was passed in the context of migrant workers. After this notification, various state governments, including the governments of Maharashtra, UP, Delhi, Telangana, issued their own state notifications because under the Disaster Management Act, this falls under a concurrent list and both the center and the state can make laws. So these states also issued their own individual notifications specifying that employers should continue to pay wages and salaries to employees and that they should not terminate services during the period of this lockdown. What happened thereafter is interesting. A number of small scale and medium scale enterprises got together and approached the Supreme Court and various high courts at the same time, claiming that it was totally unfair on them to be constrained with this obligation. When there was no income, they were finding it very difficult to make full payment of wages to employees. And so they filed these petitions before the Supreme Court, claiming relief and also challenged the constitutional validity of these notifications concerning labor and wages issued under the Disaster Management Act. Initially, when the matter came up in April, Supreme Court took notice, issued notice to the government and asked them to file a reply specifying how they plan to implement these notifications. And a particular fixed period of time was granted to the government to come up and file a detailed reply. Thereafter, on the second occasion when this matter came up for hearing, Supreme Court granted a pro-employer order in certain cases saying that there will be no coercive steps taken against employers who fail to make full payment of salaries and wages as a result of the lockdown, as they are equally affected like the employees. Then what happened was very significant. On May 18th, when the lockdown was extended for the fourth time, the central government, in the guidelines which extended this lockdown, they revoked the March 29th circular, which called for compulsory payment of wages to laborers and workers. So as far as the central circular is concerned, they have already revoked it. Now, the state circulars, including the Maharashtra notification, continues to remain alive. And consequently, the challenge in Supreme Court and the Bombay High Court also continues to remain alive as far as it relates to two aspects. One is the challenge to these state notifications in that sense, which have not yet been revoked. And number two is the challenge in connection with the interim period between March 29th, when the notification was initially issued, to May 18th, when the notification was withdrawn. There is total uncertainty as to what will happen as far as that interim period was concerned. So the Supreme Court cases and the High Court cases are still alive. And the challenge has now been modified to the extent of these 2 points, which I just highlighted. In fact, as we speak, this matter had come up for hearing today before the Supreme Court. And the Supreme Court has given time to the government for one more additional week to file a reply and make it stand clear as to what is the plan on implementation of these notifications. But as we saw, there have already been interim orders passed which work in favor of employers, which say that there will be no coercive steps taken against employers in case they are unable to meet or comply with these notifications issued from time to time. So we also read today, there was another case where the jute manufacturers had approached the Supreme Court asking for a similar relief. And there also, government has been given time to come back with a reply. And in the meantime, there will be no coercive steps taken against the employers. So this is a unique situation where all the parties in that sense are suffering. And the best approach would be an approach which is amicable and conciliatory, where employers and employees can work out their solutions and the way forward and deal with the situation in a unified way, which will be in the mutual interest of both the employers and the employees. So this is as far as it relates to the aspect of payment of wages. It is a live matter. I will try and keep all of you updated as to what happens when Supreme Court finally decides this issue, particularly to deal with the state notification in Maharashtra, for which many of us will in that sense be directly relatable to. Finally, we come to our third topic, which is another very interesting issue about payment of rent and COVID-19 lockdown. Now, here, like any other contract, an important thing to be kept in mind is there are two aspects, a contractual aspect and a legal aspect. If your contracts, your lease agreements and your Leoben license agreements have a force majeure clause which provide for suspension or deferment in payment of rent, that clause will be upheld by the courts. That has already been indicated by the Delhi High Court in a case which I will just highlight. But it is important, at least for future contracts, keep this in mind. Provide in each and every lease and Leoben license agreement, as a tenant, as a landlord, events of force majeure which will result in the suspension of payment of rent in the short run. The liability, of course, can start once the force majeure event abates. And therefore, having a contractual right will keep you on a very different pedestal where you can invoke this contractual right, which otherwise may be very, very difficult to invoke if you do not have. So for instance, if you were to talk about the legal aspect, now in terms of leases, if there is no force majeure clause in your contract, you will be governed by the Transfer of Property Act. Section 108 of Transfer of Property Act says that a lease agreement can be terminated only in case of an event such as a flood or a fire or an irresistible force which completely destroys the property or renders it unfit for use permanently. Now, if you apply this clause, which is the only legal provision, which applies in this case. Concept of frustration, to keep in mind, will not apply to lease agreements. That has been clarified by the Supreme Court. But you have Section 108, which is akin to frustration. So if you were to apply the principle of Section 108 and the irresistible force doctrine, do you think it will apply to COVID-19 and the lockdown? It will be very, very difficult, because the answer which you will get is that this is a temporary event. There is no permanent destruction of the property. The property is not rendered permanently unfit for use. So therefore, as I said, it is imperative that, keeping the future in mind, we have in our lease and leave-in license agreements force majeure clauses which specify the rent payment obligation will be suspended during the period the force majeure event continues. And I have seen many lease agreements which say that, for instance, the event continues for 30 days or 45 days, the agreement can also be terminated. Just last week, to summarize what I've just said, there was a judgment passed by the Delhi High Court in the context of a case in Khan Market concerning a shop. The shop owner had approached the Delhi High Court asking for suspension of rent because of the lockdown, and because the shop was not open, there was no income, and he asked for suspension from payment of rent. Now, the court saw that there was no agreement which had a force majeure clause. The court said that had your agreement had a force majeure clause, things would have been very different. We would have enforced the force majeure clause. We would have suspended payment of the rent. But in your case, there is no force majeure clause which will come to your rescue. Applying Section 108 of the Transfer of Property Act, again, the court said that COVID-19 and lockdown is a temporary event. It cannot be considered something as an irresistible destructive force rendering the property permanently unfit. And therefore, no relief was granted. Of course, these are the legal principles which courts have, but they also have the equity jurisprudence and equity jurisdiction, where they can work out solutions which are working solutions in times of crisis. So parties are made to agree on working solutions, which obviously are the need of the hour. And even if you look at the concept of rent, a cue can be found from how countries like Singapore, Germany, and UK are dealing with the situation. They have passed a law where a 3-month moratorium has been put on any landlord who wants to try and reclaim a property on the ground that the rent has not been paid. So no litigation can be initiated by a landlord in Singapore, UK, and Germany for a period of 3 months. So that liberty, that time has been given to tenants to make good and make the payment, because obviously everyone is suffering as a result of the lockdown. Even in this situation, it is best that landlord and tenant can work out working solutions, keeping in mind the long-term relationships, rather than taking recourse to the court route. It is a time where one needs to look at conciliatory approach, an approach of compromise, an approach of amicable settlement. And we have seen a number of lease and leave-in license agreements where various differences are sorted out between the landlord and the tenant by way of inter-party discussion. Looking at the whole situation, it is best to understand that even a bad compromise is better than a wonderfully good-looking lawsuit, because litigation is a legal right which ensures that every corporation spends at least a decade in court, and you want to be away from it as far as possible. So therefore, the need of the hour is to try and work out conciliatory solutions which are in the interest of all the parties. And again, we can look up to countries like Singapore, which very interestingly, last month passed a new legislation called the COVID-19 Temporary Measures Act, which provides a moratorium of 6 months on starting any litigation in connection with certain contracts like construction contracts and tourism contracts, which have suffered immensely as a result of this lockdown. So no litigation can be initiated for a period of 6 months. So this measure gives parties enough time to work out solutions, to come at amicable settlement where no party is rushing to court by way of litigation to try and enforce rights. So that again is a very, very important step which has been taken and which we can learn from other countries who are successfully implementing these steps. In fact, what I will do, I will also send all of you 2 articles, one by my colleague Smriti Singh, who has written an article on this aspect about the Singapore law, which may be very interesting for all of you to read. And second, by one of my colleagues, Khushil Shah, who has also written an article particularly answering a number of questions which arise frequently in the context of rent and leave-in license. So these articles may be helpful to all of us, which I will circulate, and I will request Mr. Atia to circulate to all of you, which may be of some use to you all. Finally, to conclude, I would like to end by this remark that the profession of law and businesses in India have one common thread. And that thread is the success exhibited by the Parsi Zoroastrian community over a number of years, over decades, over centuries in law as well as business. And there is a reason for these success stories. And this reason is a system of support and interdependence that we have created amongst us, where we support larger businesses, support smaller businesses, successful professionals support upcoming budding professionals. And this system of interdependence has also created a system where there are a number of role models to follow. As a result of interdependence and role models, our community has consistently succeeded. And you just have to see for yourself. You look at the profession of law, you look at the business, large business houses like the Tatas, the Shapoorji Pallonjis, so many of them in various sectors are Parsis. So many of the professionals you go to see are lawyers who are Zoroastrians and who are Parsis. And WZCC has been enshrined on these very principles. It stands on the edifice of professionalism, entrepreneurship, integrity, support, and cooperation. WZCC provides entrepreneurs with a platform where they can access business contacts, networking opportunities, knowledge sharing, and also to very much needed resources in the initial stages of business. So that is something crucial for many young entrepreneurs, which WZCC supports wholeheartedly. But most importantly, what WZCC does, and the most significant contribution of WZCC is what I call is creating a circle of hope. Now, what I mean by a circle of hope is that I've seen through my interactions with WZCC and my participations in various committees of WZCC is that our community has a number of young entrepreneurs who have the drive, who have the skill, who have the knowledge, who have the expertise, but who do not have the resources to give effect to their dreams. WZCC provides these entrepreneurs with opportunities and access to very much needed initial resources, funding, and also access to guidance of well-established mentors. These entrepreneurs, through their success stories, become the brand ambassadors who carry forward the message of WZCC. WZCC walks its talk through the success stories of these entrepreneurs. WZCC sows these seeds which blossom into fruits on this vibrant tree, which is the Parsi Zoroastrian community. And tomorrow, when these entrepreneurs come back to WZCC, they will contribute by way of their time, their energy, their expertise, and their experience, which will come in handy for the future generations, for the future budding professionals who will learn from their experience. And this cycle passes from one person to another person as it becomes a complete cycle and completes what I call a circle of hope. Last Sunday, I read an article by one of the leading members of WZCC, Mr. Adi Siganporia. And he rightly says that because of the lockdown, there is a situation where companies are taking harsh measures and cutting jobs. He rightly says that now is the time to shift to entrepreneurship. Now is the time to take control. Now is the time to become masters of your own destiny. Ladies and gentlemen, WZCC provides you with these opportunities and a platform to give effect to your dreams. Opportunities do not make appointments. You have to grab them as and when they present themselves. And these opportunities are now available. WZCC welcomes every member of our community with open arms to register as member, come and join us, join in this amazing journey which is defined by the success stories which culminate out of the WZCC experience. It is a simple process. You can click, it's one click away, you can register online, or you can contact Mr. Aspi Atia, who will guide you through the process of enrolling as members, where you will avail these benefits from WZCC and which you can contribute. You can become a part of this journey where you will contribute to the future generations and complete what I call is this circle of hope. Ladies and gentlemen, I would like to conclude by saying that these are testing times and our mettle will be tested in these times. And the key to success is and lies in what we call adaptability. As they say, life is not about waiting for the storm to pass. It is about learning how to dance in the rain. Thank you very much, everybody, for a wonderful session. And I'm very, very grateful to all of you for a very, very patient hearing. If there are any questions which I can take, I'll be happy to take them. Or what we can do, I'll request Mr. Tantra, who has already put up my email ID on the screen, where questions, if anyone have, they can address these questions to me, and I will reply to these questions.
Hello. Hello.
Hello.
Hello. Hello. Hello.
Yes, go ahead. Go ahead, Adi.
Yeah.
We can hear you.
Yeah. Am I audible to everyone?
Yes, please. Go ahead.
Okay. I am Adi Siganporia here. It gives me great pleasure to thank Mr. Zerick Dastur for his very lucid, very simplified talk which he has given on a subject which are certainly very complicated. I remember a long time back when Dr. J.J. Irani was addressing us in Tatas, and he was telling us that quite often when I go to lawyers, they always tell me, sir, on one hand, your case is like this, and on other hand, there is another case is like this. So I used to tell them, please tell me on only one hand, what is my problem. I'm glad that Zerick Dastur has in a very simplified manner, has explained to these complicated issues, along with practical examples, which certainly are very useful to all of us. Zerick, thank you so very much for spending your valuable time with us. And you have mentioned about the work being done by WZCC. WZCC is an excellent platform for one and all, particularly in our community where the youngsters or anybody else can get great advantage by participating and becoming members. Our activities are far and wide. Our spectrum of activities is very wide. And I am sure people who become members will greatly benefit in improving their business performance. Zerick, I have no adequate words to thank you. Deeply grateful to you. And on behalf of all the members and non-members who are here with us, I appreciate your efforts and wish you more and more success as the years go by. Thanks a lot.
Thank you.
Not at all.